So imagine a terrifying, but honestly entirely common scenario. You walk out to your mailbox one afternoon.
Right, just flipping through the usual stack of grocery circulars, junk mail, that sort of thing.
Exactly. And tucked in there, you find a very formal-looking letter. You open it up, and it claims you owe like $1,500 to a company you have literally never heard of in your life.
Which is always a terrible feeling.
Yeah, and naturally you just assume it's a scam. Or maybe some weird clerical error. So you toss it in the recycling bin, you don't think twice about it, and you just go about your day.
Because why wouldn't you? It looks fake.
Right. But then, 30 days later, you wake up, you log into your banking app to pay rent or grab a coffee, and you discover that 25% of your paycheck is just gone, being legally seized.
Oh, yeah.
And there was no dramatic courtroom trial, you know. There were no surprise witnesses taking the stand. There was no hard evidence presented to a jury.
None of that TV courtroom drama.
None of it. Just an automated default judgment that quietly and completely legally drained your bank account.
It is a terrifying reality. And the worst part is it happens to millions of people every single year.
Millions.
Millions. What you are describing is essentially the absolute breakdown of access to justice. And it's driven by what we call the bulk debt buying industry.
Right, the debt buyers.
Yeah. These are massive companies, often hiding behind these weird alphabet soup names like LVNV funding or portfolio recovery. They buy charged-off credit card accounts from original lenders.
So it's like if I stop paying my Chase card, Chase sells it to them.
Exactly. But they aren't paying full price. Not even close. They are buying these debts in massive, sprawling spreadsheets for literal pennies on the dollar.
It's just buying thousands of accounts at once.
Exactly. And once they have that spreadsheet, they just turn around and file boilerplate lawsuits by the thousands.
And the reason it works so well for them, the reason they can just quietly seize your paycheck, really comes down to a super bleak math problem.
Precisely. The system breaks down entirely on the economics of legal representation. I mean, think about it. If you are sued by one of these bulk buyers for a $1,500 debt, you simply cannot afford to hire a lawyer to defend you.
Because the lawyer costs more than the debt.
Exactly. A defense attorney is going to charge you like around $3,000 just to take the case.
Which is just economically irrational.
Completely irrational. So the vast majority of people, and we are talking over 90% of consumers, do absolutely nothing. They just don't show up to court.
And when you don't show up, the debt buyer automatically wins.
Right. They get what is called a default judgment. That one piece of paper gives them the legal right to freeze your bank accounts and garnish your wages.
Okay, let's unpack this. Because today, our mission for this deep dive is to look at an incredibly empowering platform called DebtDefense.
Which is such a game changer.
It really is. We are analyzing how this self-help software is basically acting as a crucial lifeline. It's effectively leveling the playing field for you, the unrepresented consumer, against these massive corporate litigation mills.
It's a fascinating look at how technology is democratizing access to really complex legal strategies.
But, I mean, if the math is that broken, how did this even start? Because it feels like you would need someone crazy enough to just refuse the math to prove this system could actually be beaten.
Well, that brings us perfectly to the founder of DebtDefense, Charles. His origin story really highlights the exact vulnerability of these massive debt buyers.
What happened to him?
Well, Charles found himself in the exact situation we just described. He was served with a lawsuit over a 5-year-old charged off debt.
Oh, wow.
Yeah, and he didn't recognize the company suing him at all. When he consulted lawyers, they essentially gave him two awful choices.
Pay up or pay us?
Exactly. Settle the debt for a huge sum or pay the lawyers thousands of dollars to fight it.
But Charles didn't do either of those things, did he? He didn't settle, and he didn't pay the lawyer.
Right. Instead, he decided to just weaponize his own time.
I love that phrase, weaponize his time.
That's what he did. He spent countless hours in the library and online just teaching himself his legal rights.
Digging into the law.
Yeah, learning the rules of evidence, civil court procedure, all of it. And he went into court himself without a lawyer and basically forced the debt buyer to actually prove its case.
You called their bluff?
He did. He demanded they show the specific original documentation that proved they owned his specific debt.
And they couldn't do it, right?
No, the plaintiff couldn't produce it. The case was dismissed with prejudice, meaning they could never sue him for it again.
That is incredible.
And the craziest part, it happened to him a second time.
Wait, really? A second lawsuit?
Yes. And he beat them again using the exact same forensic approach.
And to be clear, for everyone listening, he didn't just beat some like small-town mom-and-pop collection agency.
Oh, not at all. He went up against the absolute Goliaths of the debt collection world. This was right in Fairfax County General District Court in Virginia.
Serious courtrooms.
Very serious. We are talking about major debt buyers and massive collection law firms. He successfully defeated Zwicker and Associates.
Huge firm.
Yep. He beat Jarmondy, LLC. He took down Glasser and Glasser. And he defeated LVNV Funding.
Wow.
All of this is fully documented public court record.
You know, listening to this, the way these companies operate, it sounds less like a traditional legal system and more like a factory, like an automated assembly line.
Where the parts on the belt are expected to just roll quietly into the incinerator.
Ah, exactly. It's
Yeah.
a perfect analogy.
Charles realized through those victories that the entire business model of these debt buyers relies on a path of least resistance.
Right, because they are processing thousands of lawsuits a month.
Exactly. They don't have the manpower, the lawyers, or the original documentation to fight thousands of contested trials.
So if one part on that assembly line suddenly jams the gears by demanding proof, the entire line just has to halt.
Precisely. They are preparing for you to not show up. They aren't preparing for a grueling trial.
That makes so much sense.
So Charles realized that his winning strategies in Fairfax County weren't just, lucky breaks. They were repeatable legal mechanics.
A system.
Yes. So he built DebtDefense to package his exact strategies into a tool that anyone can use. He basically took the forensic analysis that won his cases and automated it.
But here's the thing. Charles had this obsessive, almost Aaron Brockovich-style legal awakening.
He definitely did.
But the average person checking their mailbox, balancing a job and a family, they don't have hundreds of hours to study the rules of evidence.
But of course not.
So how does this software actually bridge that gap? Like, how does an average person with zero legal background actually use this thing?
The best way to describe the user experience of DebtDefense is that it's like tax software, but for defending a lawsuit.
Okay, like TurboTax.
Exactly like TurboTax.
Yeah.
You don't need to know the U.S. tax code to file your taxes, right?
Yeah.
The software translates into simple questions.
Right, just ask you what you made, if you have kids, that kind of thing.
DebtDefense is the exact same thing. You log in, and you don't need to know any legal jargon. You just answer plain English questions. Who is suing you? For how much? What are your court dates?
Super straightforward.
Then you literally just take pictures or upload PDFs of the actual lawsuit papers you were served.
And then the app just reads them.
Yep. The software's AI goes to work reading the debt buyer's documents, hunting for specific weaknesses.
What's fascinating here is exactly what the software's hunting for, because it all goes back to the fact that these debts are bought in bulk.
What's fascinating here is the concept of robo-signing. Because these debt buyers acquire hundreds of thousands of accounts in a single spreadsheet, they rarely have live witnesses who can personally testify to the history of your specific credit card account.
Because they don't know you. You're just a row on a spreadsheet.
Exactly. So to file a lawsuit, they rely heavily on robo-signed paperwork. They submit affidavits and bills of sale that were generated in bulk and signed rapidly by corporate employees.
Employees who have zero personal knowledge of your actual account.
None. They're just stamping their names on templates over and over. DebtDefense's algorithms scan this submitted paperwork to find the fatal flaws that expose this robo-signing.
Okay, give me an example of a fatal flaw. Like, if I'm looking at this paperwork, what does a robo-signed flaw actually look like on the physical page?
One of the most common issues the app finds is a mismatched notary date.
Okay.
Think about what a notary does. A notary's only job is to personally watch someone sign a document and swear that it happened on a specific day.
Right, they stamp it and date it.
Well, the software might flag that a notary's acknowledgement on a corporate affidavit is dated, say, May 28th. But the affidavit of sale itself, the document they supposedly watched get signed, explicitly says it was created on June 16th.
Wait, really? So it was supposedly notarized weeks before the document even existed?
Exactly. It happens all the time. It's a massive, glaring red flag that proves the paperwork is just an unverified, bulk-produced template.
Because the notary couldn't possibly have watched them sign a document that hadn't been drafted yet.
Exactly. Another major flaw the software hunts for is gaps in the chain of title.
Chain of title, like a car title. You have to prove exactly who owned it and when they sold it.
Exactly like a car title. When a debt is sold from a bank to a buyer, and maybe to another buyer after that, there has to be a clear, unbroken chain of documentation proving ownership.
Right.
The plaintiff will submit a bill of sale that says, "We bought the accounts listed in Exhibit A, But when the app reads the attached Exhibit A, it discovers that your specific name or account number isn't there at all.
It's just blank.
Or it just lists a vague 7-digit bulk portfolio number. There is no actual proof connecting you to that specific sale.
Okay, I totally get that. But, and here's my pushback. If I'm using this app and I find a mismatched date or a missing name, I still have to stand in front of a judge.
Yes, you do.
I can't just walk up to the judge's bench, wave my iPhone at them, point to a typo on a PDF and say, hey, I found a typo, I win. How does this software actually translate a typo into a real legal defense?
You're absolutely right to push back on that because that is a crucial distinction. Identifying the flaw is completely useless without the procedural fluency to enforce it in a court of law.
The judge isn't going to do the work for you.
Never. And this is where DebtDefense moves from being a simple document scanner to becoming a highly effective legal weapon. The app takes those identified flaws and generates court-ready armor.
Meaning, it doesn't just hand you a blank, fill-in-the-blank template that you have to figure out yourself.
No, not at all. It creates highly specific, localized forms. It is currently built specifically for Virginia courts, with Maryland and D.C. coming next. The documents it generates have the proper legal captions, numbered paragraphs, pro se signature blocks, and certificates of service.
All the formatting stuff.
Exactly. It handles all the tedious formatting details that get pleadings accepted by a court clerk instead of just tossed out on a technicality.
And it arms you with a specific defense toolkit based on what the AI actually found.
Right.
For instance, to avoid that default judgment from happening in the first place, it generates a grounds of defense to formally deny the allegation.
Which is step one.
And if the lawsuit is incredibly vague, which, let's be honest, they usually are, just saying you owe us money, it generates a motion for a bill of particulars.
I love that motion.
Right. It legally forces the plaintiff to itemize exactly what they claim you owe, line by line.
And if the process server just threw the papers on your neighbor's porch, the app gives you a motion to quash to challenge the improper service.
So it gives you the exact procedural vehicles required to make the judge look at those mismatched dates and chain of title gaps.
Yes. But while those defensive motions are vital, the platform also offers a brilliant offensive strategy.
Yes. Okay, here's where it gets really interesting, because the app utilizes a strategy that is essentially legal judo.
It really is.
I was initially pretty skeptical when I read about this because it involves mandatory arbitration clauses. And aren't arbitration clauses usually a corporate trap buried in the fine print of your credit card agreement?
Oh, they absolutely were designed as a corporate trap. Historically, back in the 90s and 2000s, banks wrote those dense arbitration clauses into their terms of service to protect themselves.
Because they were getting sued.
Right. They were facing massive class action lawsuits from consumers over hidden fees. The banks realized that by forcing all disputes into private arbitration, they could block consumers from banding together in public court.
It isolates the consumer.
Exactly. It makes it too difficult and expensive for an individual to fight back.
But the app flips that entire concept on its head. It weaponizes the bank's own shield against the debt buyer.
It does, by completely shifting the economic leverage. You see, that arbitration clause doesn't just bind the consumer, it's part of the contract.
So it also binds the debt buyer who eventually purchases the account.
Exactly. When DebtDefense recognizes that your original credit card agreement had an arbitration clause, it generates a motion to stay pending arbitration and a formal demand for arbitration.
So you are legally asking the public judge to pause the lawsuit and move the entire fight to a private arbitration forum, like the American Arbitration Association.
Yes.
But why is that a good thing for the consumer?
Because of the fees.
Ah.
When the banks set up these arbitration systems, consumer protection watchdogs pushed back hard. To get the courts to legally uphold these clauses, the arbitration forums had to create consumer-friendly fee schedules.
Meaning the consumer doesn't pay.
Right. Under the rules of groups like the American Arbitration Association, the business, not the consumer, has to pay the vast majority of the administrative and arbitrator fees.
Oh, that is the checkmate right there.
You really...
You have a debt buyer who spent, maybe $40 to buy a $1,000 debt? They filed a cheap $50 lawsuit in public court, hoping you just wouldn't show up. But suddenly, because you use this software to invoke their own contract, they're legally forced into a private arbitration forum where they have to pay thousands of dollars up front just to get the arbitrator in the room.
The math completely breaks down for them. It becomes economically disastrous for the debt buyer to pursue you.
So what do?
Often, when faced with those shifted arbitration fees, the debt buyer will simply file a non-suit, which is a voluntary dismissal of their own
They
case.
just walk away.
They walk away because it's too expensive to fight.
That is brilliant. But let me play devil's advocate here for a second.
Sure.
This arbitration flip sounds foolproof on paper, but we really have to look at the reality of stepping into a live courtroom. The legal system is deeply, deeply asymmetrical.
It is.
If the debt buyer decides they aren't going to fold and their seasoned attorney shows up to fight, the software isn't standing at the podium with you. You are still an unrepresented consumer facing a professional litigator.
That is a very real risk, and we have to navigate the reality of the courtroom. The biggest danger a pro se defendant, meaning a defendant without a lawyer, faces is the hearsay trap.
The hearsay trap.
Yeah. Let's say you use the app to generate a subpoena duces tecum under Virginia Penal 16.1-89, demanding that the debt buyer produce the true bill of sale.
Wait, time out.
Yeah.
Subpoena duces tecum. Motion in limonigo. Stop. Lawyer speak. What does that actually mean if I'm standing in front of a judge in real life?
Fair enough. Let's translate that. Basically, the rule of hearsay means you can't just submit a piece of paper as truth if the person who wrote it isn't there to swear it's real.
Right, like if I tell you my friend saw a ghost, you wouldn't just take my word for it. You'd want to question my friend.
Exactly. That's hearsay. A subpoena duces tecum is just a fancy Latin way of saying bring the actual original documents to court.
Okay, so I demand the original documents, and I
Right.
demand the person who wrote them. What's the trap?
The trap is the business records exception. It's a massive corporate loophole.
Oh,
The debt buyer's lawyer will tell the judge, Your Honor, we don't need the person who wrote this to be here because this is just a routine business record. We keep these every day. Just accept it.
the judge usually does.
Very often, yes. And a motion in limine is your tool to fight that. It's a formal request you make before the trial starts, asking the judge to throw that bad paperwork in the trash because it's not a reliable business record, it's a robo-signed template.
Okay, that makes sense. But I mean, if you don't know how to verbally argue that on the spot, you could just freeze.
Absolutely.
You're standing in front of a busy judge who has like 100 cases on the docket that morning, and the opposing lawyer is just throwing case law in.
Exactly. And the dangers extend beyond just oral arguments. There are strict deadlines and procedural traps everywhere.
Like what?
Well, the software itself has very clear, honest disclaimers stating that the dates it computes may be incomplete or wrong. For example, if you lose in a Virginia General District Court, you have a strict 10-day window to file a de novo appeal.
Meaning a brand new trial from scratch in a higher court.
Exactly, a fresh start in circuit court. But if you miss that 10-day window, even by one single day, because you miscalculated the calendar or the app made an error, you lose everything. The judgment is final.
Wow. Not to mention the risks of the arbitration strategy itself. If the debt buyer does decide to bite the bullet and pay the thousands of dollars in arbitration fees, you are now trapped in a private closed-door room.
Yeah.
You are facing a corporate attorney with severely limited rules of evidence, and your right to appeal an arbitrator's final decision is almost non-existent.
It is absolutely a high-stakes game of chicken. And stepping into a courtroom or an arbitration hearing without a lawyer carries profound risk. There is no getting around that.
So what does this all mean? If there are these massive risks, if the user still has to stand up in court entirely alone, why is this tool generating so much momentum? Why is it considered such a lifeline?
To understand that, you really have to look at the alternative. We cannot demand absolute perfection from a software tool when the baseline alternative for these consumers is absolute zero.
That's a great point.
Yes, there is risk in using an automated legal tool, but without this software, over 90% of these cases end in default judgments.
It just lose automatically.
The consumer loses by default, their wages are garnished, their credit is destroyed, and their financial life is ruined without a single piece of evidence ever being scrutinized by a judge. Debt defense gives them a fighting chance where absolutely none existed before.
It gives them the exact map they need to even enter the arena.
If we connect this to the bigger picture, the true power of this software isn't just winning individual cases, it's friction.
Friction, I like that.
Even if the app isn't flawless, even if every case doesn't end in a clean dismissal, it fundamentally disrupts the economics of the debt-buying litigation mill.
By making them work for it.
Yes, by introducing massive friction, by forcing plaintiffs to actually prove the chain of title, by making them respond to discovery requests, and by weaponizing their own arbitration fees against them, it breaks the assembly line.
because the debt buyers rely on the fact that nobody fights back.
Exactly. When software empowers thousands of people to suddenly stand up and demand their rights, the entire industry has to rethink its model. Friction is victory.
It really is a massive shift in power. Debt defense is taking legal strategies that were previously locked away behind a $3,000 attorney paywall and democratizing them.
It really is.
It is taking the opaque, intimidating, Latin-filled language of the courts and translating it into plain English, actionable steps. It is a crucial, highly accessible lifeline that is saving unrepresented consumers from certain defeat.
And it proves that you don't need to be a lawyer to demand that the legal system actually follow its own rules.
Absolutely.
It leaves us with a fascinating and, frankly, provocative thought to consider as we wrap up today's deep dive.
Let's hear it.
We are watching automated software level the playing field for consumers. But how long will it take for the court systems themselves to recognize what this technology is exposing?
Oh, that's interesting.
If an AI app in a consumer's pocket can so easily highlight the fatal flaws, the mismatched notary dates, and the chain of title gaps in how bulk debt is litigated, maybe the courts will eventually stop accepting this robo-signed evidence by default.
They'll have to adapt.
Perhaps the legal system will be forced to catch up, changing its own evidentiary rules to address the very flaws this technology is currently beating them with.
Wow. Think about that next time you check your mail. The automated machine that sent you that terrifying letter might just be completely undone by the automated software in your pocket. Keep pushing back, everyone. We'll catch you on the next deep dive.